Hi everyone. In this case video, we're going to be looking at the second of our economic duress cases with the Sundell and Sons case. And this case involved a threatened breach of contract. So it's a little bit different to the other economic duress cases that we've looked at so far. Okay, so in this case, the parties the Sundell and Sons contracted to purchase 88 tons of governor's iron at the price of £109 per tonne. In the meantime, before the delivery of the iron, the price of zinc went up, skyrocketed, and so the other party, the defendant here, requested an increase in price. Okay? All right, let's get my screen back up. So they requested an increase in price to £140 per tonne. Okay, so it's quite a significant increase in price there. But the contract had obviously already been agreed prior to that, was already formalised. Now, the plaintiff, Sundell and Sons, agreed to vary the contract. So they agreed to the new contract price, but they did so under protest. And in this instance, they had little choice but to agree to the price hike because they had already committed to contracts with the Queensland Housing Department. Okay. Now, this case dealt with what's really, or you might notice, is a consideration issue. Because there was the new agreement between the parties, one of the questions looked at by the court was whether there was consideration for the entry into the new contract. So one thing that you guys need to keep in mind, given this case is from the 1950s, this is pre-practical benefit test. This is before Musumeci. This is before the Williams and Roffey brothers case. Okay? Now here it was held that because the defendant promised nothing more than what they had promised under the original contract in terms of the delivery of the same tonnage, it's just the price that had changed. They found that there was no fresh consideration here. So there was simply a promise to perform a pre-existing duty. So that was the consideration aspect of the case. And in terms of economic duress, the operative issue was whether the threatened breach of contract that they'd done, whether that was an illegitimate pressure. Okay? And in this case, the court found that it was, and we'll come to why in a moment when we look at the course case reading questions. In terms of the case reading guide here, the first question was, okay, so in this case, the appellant argued that the respondent had paid the additional money to purchase the galvanised iron under a contract. The court said that the respondent did not make the promise alleged by the appellant. But it also said that even if the promise were made as alleged, it was not binding. Why not? And the reason being, as discussed, there was no consideration provided for the second contract. Okay, so looking to the next question then, in this case, the appellant was not seeking to enforce a promise to pay additional money. The money had already been paid, so this is obviously different to the Hawker case, the helicopter case. And in this instance, they were seeking to recover the money that they'd paid, the additional amount, the difference between the $140 pounds per tonne and the £109 pounds per tonne, which was the original agreement. So how did the appellant seek to distinguish the Smith and William Charlick case? Okay, so in this instance, there was no threat to person or property. So in this case, the threat was the refusal to perform a contractual duty. So it's a little bit different to the Smith case, although Smith case involved the party was seeking to be refunded, get back the money that they paid under the contract in the circumstances of duress. In terms of the second part of the question, so what was the pressure exerted by the appellant in our case here, in Sundell and Sons, and why was it illegitimate? Here the pressure exerted was withholding delivery of goods, which the appellant knew the respondent had an urgent need for because of that contract they had with Queensland Housing. And this was seen to be illegitimate here because the appellant had that already pre-existing contractual duty to provide the goods. And the respondent had already upheld their part of the bargain by providing the letter of credit as requested. Okay. In terms of the third question, then given what the Court of Appeal said in Hawker, Pacific and Helicopter Charter about the distinction between claims to recover money paid and claims to set aside promises to pay money, it follows that a promise made to avoid a threat to breach a contract can be set aside on the grounds of economic duress. Okay, so that's what this case is held up as, I guess, authority for. So a threatened breach of contract can amount to economic duress. Now, in the question, we've asked you to have another look at Musumeci, which is the practical benefit test case. Okay. And we've asked you to explain why the promise to pay additional money in this case wasn't binding. As mentioned, the Musumeci case came 40, 45, 40, 44, 43 years later, after this, after the Sundell Sons case, so it's coming decades later. So Sundell was well before the practical benefit test was around. And in that case, you know, that still case, the principle of the pre-existing legal duty not being sufficient consideration, that was that dominant authority that was around at that point when the Sundell Sons case was decided. So just here, you know, was there any meaningful consideration? No, there wasn't, because the promise to pay additional money was not in exchange for anything, okay? The consideration was illusory, and the variation, so that new contract, was therefore void. So the original contract was held to stand, and the promise to pay the additional money wasn't enforceable. In terms of Musumeci as well, so Musumeci takes that flexible practical benefit approach to consideration, but it was decided partly on the basis that economic duress gives better protection to the promiser from extortion than the requirement for consideration. So arguably, even if there had have been a practical benefit considered here, or even if Sundell Sons had been considered after 1994 when Musumeci was decided, you might still have found that the court would decide that this was still a clear case of economic duress, even if there was a possibility of a practical benefit for Sundell in being able to complete those Queensland contracts in time. So, you know, if you were ever responding to a problem question that had a threatened breach of contract in it, and there was a variation, you know, in that standard kind of practical benefit case type test, type scenario, I mean, what you would do is you'd raise it as a consideration issue and then say, regardless of whether there was sufficient consideration, you still need to consider whether this would amount to economic duress, and then apply the duress principles, including this case. Okay.